Good morning, Harney County. This is Commissioner Patty Dorroh. Today is March 29th, 2021. It's about 7:37 in the morning. And I just wanted to talk about some of the things that have been on my mind around Second Amendment rights and protections and legislative things happening. Um, if you believe that the right to self-defense is absolute and that the right to bear arms for that purpose is constitutionally guaranteed, then you will probably agree that Second Amendment rights are under legislative attack in Oregon. Last week on Thursday, March 25th, the Oregon Senate passed Senate Bill SB 554, which reduces the ability for and criminalizes presently lawful concealed gun carry by allowing cities, counties, municipalities, school districts, airports, and a few other categories to make their own local decisions on whether to allow or deny the right to carry in their buildings, grounds, or attended property. The problem is that those who are licensed for concealed carry did so for their own protection reasons, and that the timing and location of their need to be prepared for their self-defense cannot be controlled, predicted, and fenced off from their ability to freely conduct their business and live life. Those who are the danger that gun carry mitigates will not obey the new laws, but this forces the concealed weapon permit holder to either violate law in order to continue to protect themselves or accept the increased risks and dangers that cause them to get a concealed permit in the first place. Republican senators did not opt to deny quorum on SB 554. The result is the bill passed and will be going to the Oregon House, where the Republican representatives, as you know, are also in the superminority there. Various other gun-related bills were proposed during this state legislative session, and the trend is for that to continue into the future. Onerous, micromanaging, and unreasonable bills have been developed and were proposed, restricting and dictating how people would have to store and transport their weapons in ways that would negate common sense and their very ability to successfully access their weapon in a timely and safe fashion for defense. Best I can tell, as of today, the following bills are active and infringe on Second Amendment rights. House Bill 2543 eliminates the protection gun buyers have if the state police can't or won't complete a background check at all or in a timely manner. If the state police don't complete the check, you cannot buy a gun until they do under this bill, even if they are a year behind in getting them done or never get them done. Right now, there's a 3-day period for it to be done, or at least you can buy the gun until further notice. House Bill 2510, a mandatory lockup bill that says locking up your gun is only considered lawful lockup if there is absolutely no potential that the lock could ever possibly be breached. That's an impossible standard. This means locking it up in your car won't cut it when you have to secure it to go into a federal building or into so many other of the patchwork of locally prohibited gun carry buildings and grounds that will emerge across Oregon with the passage of Senate Bill 554. House Bill 3005. This bill is simply a one-line bill that repeals the Oregon statute creating state preemption of local firearm regulation and the statutes that created the exceptions to the preemption. Exceptions are needed. The result is an attempt to enable nullification of local laws and ordinances, such as Second Amendment sanctuary ordinances, or SASOs, not through court decision, but by having sheriffs take on the judicial role of courts in determining if a law is something they need to enforce, if it's legal or not. The role of the sheriff is to enforce the law and not determine if laws pass legal muster. That is the job of the courts. With a supermajority of liberal legislators, the outlook for those who believe that the laws we already have are sufficient for public safety and our constitutional rights, that outlook is not good and it's getting worse. We look to the courts to uphold the Constitution, and we should not have to fight so hard to defend our rights. But the judicial branch, both at the federal and state levels, has become highly partisan. Just last week, March 24th, the majority of an 11-judge panel on the Ninth Circuit Court of Appeals concluded that the Second Amendment does not guarantee the right to carry firearms outside your home. Although some circuit courts have upheld restrictions on carrying guns in public, Attorney Alan Beck of San Diego argued that no court has gone as far as the Ninth Circuit did in its opinion on Wednesday. His quote, "The Ninth Circuit Court's opinion, which finds the Second Amendment right does not apply outside the home at all, contradicts the decisions of every federal circuit court in the country that has ruled on this issue. We will be seeking Supreme Court review in order to overturn the Ninth Circuit's erroneous decision." There is a rural-urban divide, and it seems to be increasing. At the county level, we work through our state representative and senator, as well as county commissioners, directly advocate, educate, and testify for our people and communities. Some counties, Harney County among them, passed Second Amendment preservation ordinances that focus on affirming county commitment to support Second Amendment rights and to oppose efforts contrary to those rights, and emphasize that the county will not authorize or appropriate government funds, resources, employees, agencies, contractors, buildings, etc., for the purpose of enforcing any elements of such acts, laws, rules, and regulations that infringe on the right to keep and bear arms. The voters of some counties, such as Umatilla and Columbia, have passed Second Amendment sanctuary ordinances, or SASOs, to defend against enforcement of state laws that infringe on Second Amendment freedoms. Yamhill County Board of Commissioners recently held multiple work sessions and are now about to enact a SASO on behalf of their county, and their version of the document has improved from the previous ones. Harney County is going to be having discussions around that topic. Whether or not county SASOs will be challenged over time, I do not know. Any and every law or ordinance can be challenged at any time, whether it's a Second Amendment one or not, and it's reasonable to anticipate it. Yet the specter of a legal challenge itself, in my view, should not deter counties from doing their part for the good of their county. In fact, I have heard people say that the only thing that can save this state is the counties. It's fundamentally unfair, in my view, when the state legislates to preempt U.S. constitutional rights in bills like Senate Bill 554, while citing the state Constitution preemption clause and trying to repeal those exceptions to try to limit the county's ability to defend our Second Amendment rights. The SASOs use the term sanctuary in the same way and for the same purpose that the state of Oregon chose to use that term to become an illegal immigration or undocumented alien sanctuary state. Shouldn't it work both ways and counties have the same option or simply do it? The attacks and pressures are real. I wish I had better news for you right now. These things are worth fighting for, and we need to do our part. Please contact me at any time if you have some good ideas, approaches, or just want to discuss it with me. Thank you very much for listening.